A moot is usually like a mock trial, but in this case, actually, it's a negotiation. So in the case of the Kawaskimhon Moot, it's a non-adversarial negotiation. So usually what happens with this moot specifically, it's on an Indigenous issue. So what happens is we create a moot problem if you are the facility or the faculty that is hosting the event. And usually the parties around the table, they range, but usually a lot of times it's First Nations party or multiple. Usually a government, federal government, usually a provincial government, and a lot of times maybe a potential tribal council, or in some cases, multiple resource proponents or like a coalition.
Hello friends, I am Michelle Obanswin, a proud Abenaki member of Odanak First Nation and a Turtle Clan member. I am the daughter of Richard and Ziane. Thank you for inviting me to share in this day with you. I am honored to be welcomed to the territory of the Secwépemc Nation. I want to congratulate Thompson Rivers University for hosting this moot for the first time and surely not the last. Days like these give me a great sense of pride. Decades ago, Indigenous peoples were effectively excluded from legal education and the profession as a whole. Under the Indian Act, Indigenous peoples were prevented from hiring lawyers to pursue claims, and any lawyer who defied this prohibition could be disbarred or jailed. Thankfully, we live in a very different time now. Your participation in this moot is a testament to the strength, resilience, and brilliance of those who have come before you and fought for change. Your participation in this moot is also a continuation of that legacy of resistance and negotiation both by the nations of this territory and those all across Canada. I am encouraged by what this means for our legal profession. I am also part of that legacy. When I was a law student at the University of Ottawa, I participated in this moot. It had been recently created, and I felt so fortunate to be in law school at a time when I could engage critically with the area of the law I hope to practice in one day. I am so pleased that this moot continues today and that students from universities across this country are learning and practicing what it means to apply Indigenous and Aboriginal law. The more lawyers we have who are knowledgeable about Aboriginal law and legal traditions and customs, the richer our law becomes.
First and foremost in our mind is honor the territory that we're in, right? So having a problem that was relevant, but yet culturally appropriate and wouldn't inflame anyone, right? Whether it's non-First Nations or First Nations. So with the problem that we designed around was PIPSL, right? Because there was matters that came up regarding the Ajax mine that was resolved. Now there's some matters with the Trans Mountain Pipeline, and they're working through that process. So we thought it was fantastic to honor the territory. The next thing that we were really looking at and was forefront in our mind is the participant experience, the Mooters. We wanted them to have the most amazing experience that they can possibly have, and the coaches, because we had 20 law schools from across Canada, most of them with 2 teams. So when they came here, we wanted to represent, to Kamloops, the Secwepemc territory, Kamloops, and also the university, and specifically the Faculty of Law. And we had a great team going back to, we had a moot committee. Professor Brad Morris was on there. We had Chrystie Stewart, we had Ben Turner, Rob Houle, Miranda Seymour, and myself. So we really worked hard at it, and the dean supported it, and we're really excited about it.
My role, I guess, this weekend is a few different roles. First, I'm a coach. It's like I've been a coach for the Indigenous Moot for several years now. We have 2 teams that are entered. One that is looking at the role of what the federal government would play, and the other one is looking at the actual SSN, so the essentially governing party. I'm also on the organizing committee, and I am the Indigenous student coordinator for TRU Law. We view the moot as kind of a specialized, more substantive exercise in negotiation.
Environmental assessment process.
I think maybe this could also...
Murray Sholty has done an amazing job in organizing this moot, absolutely. It's a big deal in law to set the precedent. Very strangely, it doesn't happen that often. So TRU set a precedent running on, well, back in 2011 when this law school opened. It was the first new law school in 30 years. We were the first team to be sent to this national moot, which is said to be non-competitive. The commitment that this law school has to this moot, I think, is shown over the last few days here. So not only is this now the 30th anniversary of the Indigenous moot, the national moot, it is the 10th anniversary for our graduating class. So there's a few different kind of synergies coming to play, and I think that's quite interesting, you know, when you think about even the territory that this is being hosted on. We've got two large rivers that meet here. Sometimes I think people end up in Kamloops whether they want to or not. It's like there is a flow that brings people together here. I know that there's other moots that promote negotiation, but this is a multi-party, generally a constitutional Indigenous issue. And I think that particularly if you're going to practice law in British Columbia, you are going to work hard to avoid any interaction with Indigenous law. So I think this allows an opportunity for students to really lean into that and see the different parties that are at play. There are so many disputes that are arising, particularly with First Nations, that the courts have not been able to adjudicate in an efficient way. Eventually, they will get there. It's very expensive. Very few First Nations can afford to take their issues to the court, and you have no guarantee of what that decision is going to be. This type of moot that promotes a negotiation where you can consider all of the different parties and all of the different stakeholders. So the people that are going to be impacted by the decision but aren't necessarily a party are considered in exercises like this. And I firmly believe that this is the future of how particularly Indigenous legal issues are going to be resolved. This is where their papers come to life. So, you know, students spend a lot of time in libraries. They're very good researchers. They're obviously very smart with big brains. So that's one thing, to be able to write all of that down and get a good grade. It is another thing to be able to pull it off the page, bring it to life, and then actively debate it in real time. This is not something where you get to send your opinion over and they get to think about it for several months and then send the opinion back. It's like this is happening within a few minutes of each other. An idea is lobbed out there. They have to have a very fast consideration of whether it's legally possible. How far can we stretch the law? Where can we, move within the confines of the law? And then they have to respond on their feet. And I think that makes it very exciting. It certainly increases the energy, with looking at a complicated legal issue.
So I also want to say, for us to be here on the unceded territory of the Secwepemc, we have a special obligation towards our community. And that is why when Murray and Chrystie texted me last year and said, can we please hold the Kawaskimhon? I said, of course. Murray and Chrystie are very special to us. They are alum of our first graduating class here at TRU. They are the testimony to what can be done if a law school actually honors its obligations. In legal education, we have a unique opportunity. We actually have this special place in the world where we can be agents of change. We can recognize what is wrong in society. We can see injustices. We can look at what we do not want for our children and for those who come after. And we have an opportunity to say, there's a better way going forward. There's a better way of setting up society. There's a better way of righting the wrongs of the past. There's a better way to strive for all those ideals that we stand for. So for us, Indigenous education is not just a matter of a tick box exercise because a politician came and said, answer the calls to action. This is not what it is about. I can see someone maybe agreeing with me. It is actually deconstructing what we know about the world and to be authentically curious about what it is that we see and what it is that we want to see. So with our unwavering commitment to infuse our legal education with Indigenous content, to keep at it, to keep making sure that we produce lawyers of the future, people who will stand up for the downtrodden, people who will actually answer those calls. This is what we want to achieve, right? This is what TRU Law stands for. So thank you very much for joining us in this competition. Thank you so much for traveling all the way out to see us. You are welcome, and we can't wait to spend the rest of the week with you. Thanks so much.
SSN can bring elders and knowledge.
And that, like, should we be requesting additional funding from the Crown governments?
Creates this robust agreement. That is why.
Yuginawa, Nin Cassandra and Dishnikas, Mishki Gogamakidonji, Midash Kuchacheng, Ishkanaganeng, Geji Ombikian Gaye, Name in Dodem, Midash Bor Alaskan Faculty of Law, in Daji Gekinomage, a Nawidige Ma Bimikoe Ijinakazach Gaye, Mie. So, just an introduction about who I am. My name's Cassandra. I'm currently studying at the Bor Alaskan Faculty of Law. I'm from the community of Mishki-Gogaming, and I am of the Anishinaabe people. It's very scary. It's definitely a little bit intimidating to see so many faces around the table who are prepared to negotiate the topic. So the first day was a little bit about getting the nerves out and kind of relaxing into the negotiation process. The second day has been a little bit more comforting. Everybody kind of has a common goal in mind, and that's to work together to try to create a relationship between the Canadian legal system and Indigenous legal systems. So once we were able to come to an agreement about what we're doing at the table, it became a lot easier to negotiate with one another and become more comfortable and kind of prioritize or center the conversation around Indigenous law and specifically revitalizing Indigenous legal orders. It offers students across the country to kind of grapple with Indigenous law. I think it's an up-and-coming area of law that we're beginning to study. And so it gives students the opportunity to think critically about how an issue may be solved or come to an agreement about using Indigenous law. Currently, we're still thinking so much within the Canadian legal framework. This moot offers us the opportunity to reimagine how the plethora of laws that exist here, Indigenous law, civil, and common law, can interact with one another, have a relationship to one another, and I think it's a great opportunity to share kind of the beauty about the diverse Indigenous legal orders that exist here.
Bonjour everyone. So my name is Cassandra and my partner's name is Matthew. We represented the First Nation Alliance. We came to the negotiation table through Anishinaabe diplomacy in the process called Migas Sapikan, where you hang a wampum belt on the front of your canoe as you travel. And the goal of it is to reach the negotiation safely and be able to participate in it. Once there, we proposed the proposal of the 4 directions relationship, which is built on the Secwepemc law of observation, which looks into the all directions to find laws, guidance, and knowledge. And based on this proposal, we were able to come to an agreement with the SSN First Nation, the Kamloops to Secwepemc, and the Blueberry River First Nation. So it's a very exciting relationship that works to uphold the legal orders of one another and call on advice or participation from one another when dealing with the natural resource sector of Canada. Also, on a very personal note, we've come to the negotiation with a birch bark basket, which has been made from our territory. The birch bark basket itself has, maybe you want to walk around. We have a lovely showman right here. So the birch bark basket has sweetgrass around the top, or wingashk. This sweetgrass was gifted to us by a woman named Josephine Mandamin-Bun, who was a very revered elder in our territory. Yeah, round of applause for Josephine. Josephine Mandamin-Bun was a very revered elder in our territory that initiated water walks to protect waterways and also to raise awareness about the power of women and Indigenous legal orders. So we were gifted the sweetgrass from the family, her husband who's now surviving. And then the birch bark itself is made from the Fort William First Nation or Nimikiwaju territory, and the Pelche family made it. So Helen Pelche herself, who works to uphold the legal orders of the trees. Yeah, another round of applause. So Matthew and myself have committed ourselves to upholding Indigenous legal orders and very specifically Anishinaabe legal orders. This is our personal commitment, and we wanted to gift it to the local people of this region as a personal commitment to also uphold your legal orders. And this also aligns with the Bor Alaskan Faculty of Law's commitment to revitalizing Indigenous legal orders. So on behalf of our school, Matthew Matthew and myself, we would like to gift this basket to Chrystie, Stewart, Judge Lyndon Thompson, and the elders, if you could please come on up. And Viola Thomas.
Waita, this is a beautiful, special honor, especially for me. Josephine Mandelin was my hero. She was a water fighter. The waters are like our teachings in Secwepemc territory. We're connected to water. We are the life givers. We're born in the womb of our mothers. Our grandmothers, our ancestors have given us direction. Josephine Mandelin was a beautiful, powerful water walker who walked all the Great Lakes in Ontario. And she blessed me with a name, Nimpiwela. And so it's so beautiful that I'm here at this moment to accept this gift in her honor, in lifting up Secwepemc laws to water. You heard at the opening comments from my relative, Ted Gofferson, that spoke to the connection of women and water. And we are reminded today, this gifting is a reminder of the sacredness of the water and the connection to our life givers, to our women, to our grandmothers, our mothers, our aunties, our sisters, and our great nieces. So I'm truly, humbled, and I'm truly blessed that I have this opportunity to receive this gift in honor of Josephine Mandelin, but also in honor of the sacredness of life and the sacredness in the work that you're going to do as Indigenous lawyers, as all lawyers who are participating in this moot court, to lift up our Indigenous legal orders, to lift up our right to be, to lift up our connection to the water and Mother Earth. Our life givers, they're connected, they're one and the same. Kukshim, all of our relations.
Ooh, Steve.
I think kind of the drive to really continue to advocate specifically for Anishinaabe legal orders. I think the moot can continue to try to include more Indigenous law in the issue, in what it provides to the parties. And so I think kind of that drive to bring Indigenous law to the forefront and really advocate for the revitalization of Indigenous law, in my context, Anishinaabe law. And I think that love of my own legal tradition, my own legal order, is really what I want to continue to propel after this moot. Very grateful to be here. Nimigwech wenda momayayan. Nimigwech. Thank you.
Honestly, I've had so much fun in the past 2 days, and it just confirms what I want to do in the future. And right now, we're faced with a really complex problem, and everyone has their own thing to bring to the table. So for me, I'd say I have more experience with constitutional Indigenous law, and my teammates have more experience in business law. So we can complement each other and actually think of solutions that we wouldn't be able to think by ourselves. Also, I think what I've learned the most is how valuable actual customary Indigenous law is. So I wished we could have used those more, but just the realization of how big of a significance they carry to the Indigenous community, but as well as policies and just the overall negotiations overall. I think it's a factor that I didn't put that much time into and that I should have.
Donc c'est juste que de cette manière-là, je pense que, tu sais, juste qu'on se comprenne tous.
C'est une question d'interprétation, finalement. favoriser. J'ai fait une hyperbole. Je vais une hyperbole. Mais peu importe, dans le sens que... Quand j'étais jeune fille.
Currently, I'm a third-year student at the University of Victoria, and I'm just so happy to be here and participate in this moot. I've always been interested in entertainment law, so I want to hopefully one day represent Indigenous artists. I just agreed to do a LLM after I graduate, where I want to have my thesis focus specifically on Indigenous intellectual property rights, and hopefully in my future practice be able to tie in those understandings within the field of entertainment law. I love it. I love this moot. Coming into law school, I knew if I was gonna do any moot, it would be this one. I think it really relates to how we do things. Like for me, I work with my nation on, our child welfare legislation, our rights recognition tables with the federal government, which are predominantly negotiation based. And so this has been an incredible exercise. I think it's absolutely lived up to my expectations.
I'm really enjoying myself. It's been a thrill just getting to learn more about Indigenous law and of its application in real life. It's been really nice to just be immersed into the experience, and for it to be such a topic that's so relevant today is incredibly interesting, and I'm really happy I'm here.
Une reconnaissance que c'est ça les mieux placés.
Well, most cases actually do not go to trial. Trial is relatively expensive, so a lot of issues get dealt and resolved outside of court. So I think that having negotiation skills is really big, and I think a lot of people fail to realize that. Like, it's not all about being in court and trial. It's actually, a lot of it is outside of that setting. I highly recommend this moot. I think that it is going to make me a better lawyer down the road. I think just the negotiating skills that you come out with can be applied to any area of law you go into. So I hope that they take this into consideration and consider doing this moot.
As a recent alum, just getting to be continually involved with TRU is something that really makes me happy and excited. So it's just been amazing to see TRU get to be showcased on this sort of national level for people all over the country. I think the fun of having everyone in Kamloops is getting to share in the experience I had of being at TRU and being in the faculty, being in town. And I think TRU is known for being a collegial and welcoming environment, and I think the nature of this moot is more collaborative and conciliatory in that sense. And so having people be able to spend time and to share this space with us, to also work together, to be in collaboration, to come to try to build consensus is a really amazing thing. So I don't know if it's a surprise by any means, but it's definitely just been really cool to feel like the sort of TRU touch or echo is kind of resonating with the people here to be a part of this moot. The nature of this moot means that you have people working in collaboration, that they're coming together and they're trying to take seriously the very real world implications of the decisions being made by Indigenous groups, by governments, by nonprofits, by industry actors. And it's easy for those people to be flattened down or to be made into a simple reduction of who they actually are and the complexity that contains. So having people as thoughtful and as engaged as law students taking seriously those commitments and to work together in the spirit of collaboration and really trying to build something and not just sort of fight or to win at the other end as a zero-sum game, I think is a huge part of the value of this. And I think also to celebrate the incredible Indigenous history here on the Secwepemc territory, to help people across the country understand their role and their place in what we now call Canada, and to hopefully somewhat demystify and shed a light on the different incredible diversity of the people that spread all across Canada, including the many Indigenous peoples all over the country.
This is my second moot as a coach, and I did the moot as a student when I was in law school. I've tried to mirror my coaching style based on the way it was taught to me. I had a very good experience when I did it. And so we focus on the legal analysis of the issues and what our party's position would be, write the submission and focus on that. And then once the submissions are submitted, you receive back the other papers from your table, and then we work on what the negotiations would look like, how to be in the room, what you could expect, how to be ready to have something you haven't expected, just in terms of being aware that that could happen and the kinds of things. And the students in our room really found their footing after lunch. I think that the way the day was organized in that there were personal introductions, and so it starts out with law students meeting each other, and so it's really human and relational. And then you get into your party's positions, and then what might the end look like, you know? So what are the things we're going to talk about? What are the things that are important to each party? And so I thought, and our facilitator did an excellent job of sort of setting up some framework and the way that we would proceed. And then I felt like in the afternoon, the parties really found their footing and felt really comfortable in who they were representing and what some kind of an agreement would look like for them. And then today, the parties really hit the ground running. There were pre-meetings this morning among parties, and I think it's been an exceptional experience for my students. I think they would report that.
As a practicing litigator, 90% of my work is preparation for court. 10% of my work is actually litigating. And of that 10%, 90% of that ends up negotiating at the courthouse steps. This type of moot is really, really a good tool and a base that one can draw off of as a litigator, because you're using the art and craft of negotiation all the time. I'm on table 6. Table 6 is en français. Donc c'est vraiment important d'avoir la perspective francophone, parce que c'est vraiment une perspective unique pour le Canada, parce qu'il y a un mélange de culturels différents, comme les francophones et les francophones autochtones aussi au Québec. Donc c'est vraiment important d'avoir cette perspective. So that's really important for understanding that we live in a multinational nation, and the Quebec, the Francophone voice must be heard and the Francophone Indigenous voice must be heard in this process, in this moot, and it's great to see that. But hopefully next time there can be a lot more French and English intermixed, because I think that's that's part of what Canada is. We are a multinational nation. Indigenous and Francophone play an important role in the fabric of Canada. So having that represented here today, really important.
Olthius Clear Townshend, or OKT, is a sponsor of the Moot. We've been sponsoring it for over a decade now. So that's part of it, but my role in the Moot here is as a coach for University of Toronto law students. Our firm came into existence in order to advance the interests and the sovereignty of Indigenous nations. And there weren't a lot of places, and frankly still aren't a lot of places in law schools where that kind of work is focused on. But the Moot's one of them, and we've always really loved the Moot. We've always enjoyed, many of us participated in it. And when we came on board as a sponsor, there was some concern about the future of the Moot, what it might be. And we thought, you know what, like one thing we can do is just make sure that there'll always be money to have the Moot every year. And then other folks will host and they'll come on and the thing will happen. So it's important to us to have a space where these issues are front and center, a space where students can meet one another and share ideas and get to know one another, because often through their careers they'll continue to encounter each other if they stay in this field. So yeah, it just seemed to us like one of the better law school events and experiences out there, and frankly a little too rare in terms of opportunities, so we wanted to make sure that it kept happening. The House of Learning is like it's structurally beautiful, obviously, but it's like it has a structural impact on how people think and interact too. Like when you're sitting in a circle like that, when you can all see one another, like it's just a different kind of environment than literally across the aisle or like with a judge and people sitting like literally on a lower level. And I think we need more spaces like that, honestly. I've often thought, like, I go into not just courts, but also sort of legislatures, places of Canadian lawmaking, and I look around and I just think, like, these places have no reflection of the Indigenous peoples of these lands. And why not? Like, why would the space not reflect the reality of the country in all of its complexity, in all of its different peoples that are sharing these lands, instead of just one? Certainly, I mean, the experience of going into Queen's Park, it's almost like a monument to denial, like denial of the existence and reality of Indigenous nations. And it's high time that changed. And yeah, the House of Learning is a marvelous example of how that can happen and still be very workable for everybody. I mean, it's obviously an incredibly functional space too. So yeah, I loved it.
So here's an example to demonstrate what's possible. I began working for residential school survivors in the late 1990s. At the time, standard civil litigation was the only real recourse that was available. So I worked very hard to advance claims against Canada and churches in a timely way. I traveled to my clients' communities. I really got to know them. My clients were, if I can be frank, they were shredded by the litigation process, especially by the discovery process. Despite testifying with honesty, dignity, and integrity, they often felt disbelieved and disrespected. Nothing personal against the lawyers who were asking the questions, but I often felt the same. The questioning was always very polite, but it was obvious that some of the lawyers asking the questions were from a different world and just did not believe what they were hearing. And I don't blame them. Like, what person from their background and life experience could believe the hideous things that happened to the Indigenous children who attended Indian residential schools? But to make matters worse, it was obvious from common lines of questioning that Canada and the churches were gathering evidence to ultimately argue that survivors would have had all sorts of struggle in their lives, even if they'd not been abused at residential schools. In other words, as Indigenous people in Canada, life was going to be pretty crappy for them anyway. It was hard for my clients to understand why Canada and the churches tried to blame the hardships that they'd endured after residential school on other negative experiences that they had within their families, within their communities, and just generally within Canadian society. They thought their discoveries were supposed to help Canada and the churches understand what they'd gone through and how that had affected them. Canada and Indigenous people, as we know, have a forever relationship. And sadly, the litigation experience of survivors was only driving an even bigger wedge between them. Not good. Early on, I knew there had to be a better way, and fortunately, I was not alone. To its credit, Canada invited me, like-minded claimants council, and churches to work with them to find a more proportionate, supportive, and less adversarial way to resolve the claims of survivors. And that's something that I'd like to think we eventually achieve with the independent assessment process, or IEP, that was created as part of the Indian Residential School Settlement Agreement that was signed in 2005. As a result of creating a credible process, over 30,000 survivors advanced claims within the IEP, with the vast majority being validated by independent adjudicators. And these numbers absolutely smashed the expectations of the parties who negotiated the settlement agreement and demonstrated, to my way of thinking, what's possible when justice is done right.
My hope would be that if this moot was unique and wonderful, that it stops being unique and wonderful for the people that did it because it becomes normal. Because these ways of discussing things, the attention to these issues just becomes something that we all do, settler, non-settler, all the time. The Houses of Parliament change. Everything changes to be more inclusive, to better reflect, as I say, the reality of all the peoples here. So, I mean, it's special, but I almost hope one day it's not so special because everything is like this.